Hello friends, this is the second episode of Nyay Patsala. Today's topic is on public interest litigation, which in short is referred as PIL. Any litigation or any case filed for the protection of the public interest can be termed as public interest litigation. First, let us understand the meaning of public interest litigation under Black Law Dictionary. Black Law Dictionary defines public interest litigations as a legal action initiated in a court of law for the enforcement of public interest or general interest in which the public or class of the community have pecuniary interest or some interest by which the legal rights or liabilities are affected. The scope of PIL was first discussed by the Honorable Supreme Court in the case of Janata Dal versus H.H. Chaudhary, which is reported in 1992, 4 SCC 305. I will be mostly referring to the citations of this SCC online because I find that these are more user-friendly and it is easy to do the research and charge work in SCC online. I am a subscriber of SCC online, that's why I can say that SCC Online is one of the best legal software in India. In Janata Dal's case, in paragraph 53, the Supreme Court has said that the expression litigation means a legal action, including all proceedings therein initiated in a court of law with the purpose of enforcing a right or seeking a remedy. Normally, we file the PIL in the Supreme Court by invoking Article 32 of the Constitution of India. In case of the High Court, PIL is filed under Article 226 of the Constitution of India. Normally, a person must be aggrieved. Unless a person is aggrieved, he can't file a litigation before the High Court or the Supreme Court. In case of PIL, this concept of locus standi has given some relaxation. In this case, a person need not be aggrieved. Anyone who is interested in the cause of the public or who is espousing the cause of the public can also file a writ petition before the High Court by invoking Article 226 of the Constitution of India or before the Supreme Court under Article 32 of the Constitution of India. In PIL, normally we seek the invocation of the court's power for issuing a writ. Of course, this concept of writ will be taken up in a different discussion, but let us remember at this time that there are 5 writs which can be invoked for enforcement of any fundamental or legal right. Number 1 is a writ of chancery. Number 2, writ of mandamus. Number 3, writ of quo warranto. Number 4, writ of habeas corpus. Courts are extremely cautious to ensure that the PILs are not misused, as the misuse of PILs would defeat the very purpose for which it was conceived. It would fail to come to the rescue of the poor and the downtrodden. The Supreme Court in the case of Kusram Lata versus Union of India reported in 2006, 6 SCC 180 in paragraph number 5 that if there is material to show that a petition styled as a PIL is nothing but a camouflage to foster personal dispute, the said petition has to be thrown out. Here in this case, in Kusum Lata's case, we for the first time, the Supreme Court has used the expression like publicity interest litigation, private interest litigation, or politic interest litigation, or the latest trend, paisa income litigation. In the case of K.S. Srinivas versus R.M. Premchand, the Supreme Court observed that a writ petitioner who comes to the court for relief in public interest must come not only with clean hands like any other writ petition, but also with a clean heart, clean mind and clean objective. Where to file the PIL? A public interest litigation can be filed before the Supreme Court under Article 32 of the Constitution of India or before the High Court of a state under Article 226 of the Constitution. It is important to note that Article 32 is referred to as the constitutional remedy for enforcement of fundamental rights. This provision itself has been said in a number of occasions that it is the heart and soul of the Constitution of India. The father of the Constitution of India, Dr. B.R. Ambedkar, described Article 32 as the most important one without which the Constitution would be reduced to nullity. It is also referred to as the heart and soul of the Constitution, against whom public interest litigation can be filed. A public interest litigation can be filed against state or any other authority as defined under Article 12 of the Constitution of India. Normally, you can't file a PIL directly against a private person. If the state is a party in the PIL, then the private individual or person can also be arraigned as a party respondent in the PIL. Say for example, there is a pollution creating factory in a city. So normally the locality people of that factory or the neighborhood people can file the PIL, and even if the company or who is creating the pollution, if it is a private entity, then also a PIL can be filed. Guidelines in regard to filing of PILs. The Supreme Court of India and the various high courts have framed guidelines in regard to filing of PILs. In those guidelines, certain categories of disputes, unless otherwise directed, are not treated as PIL. Say for example, matrimonial disputes, landlord-tenant disputes, or service matter relating to pension or gratuity, contractual liabilities, etc. These are some of the categories of cases where under those guidelines the registry doesn't accept filing of PIL. When can a PIL be filed? Let us remember that the fundamental rights provided in the Indian Constitution are guaranteed against any executive and legislative actions. Any executive or legislative actions which infringes upon the fundamental rights of any individual or any group of person can be declared as void by the courts by invoking powers under Article 13 of the Constitution of India. The fundamental rights can't be suspended except under emergency, which is dealt under Article 359 of the Constitution. Sometimes in case of PIL, we have also seen the court dealing with the directive principles of state policy, which is provided under Part 4 of the Constitution of India.